Imagine finding out years later that you have a child you never knew about and then being told you can't bring them to Canada because of a technicality. Sounds unfair, right? Well, it actually happened to one Canadian citizen, and his case is a big lesson for all immigrants. Stick around because you do not want to make the same mistake. So let's talk about Mr. J. Mr. J is originally from Ghana, but he became a refugee in Canada in 1996. A few years later, he got his permanent residency, and by 1999, boom, he was officially a Canadian citizen. So life was great, but then drama. Fast forward to 2003, and Mr. J takes a trip to Nigeria. And guess what? His sister drops a bombshell. She tells him that his old girlfriend from the 80s had a son, and that son looks just like him. Plot twist, Mr. J does a DNA test, and bam, it's actually his son. So naturally, he does what every loving father should do. He builds a relationship with the boy and decided, you know what, I want to sponsor him to come to Canada. But there was one big problem. The visa officer refused the application. Why? Because Mr. J never declared his son when he first applied for his own permanent residence. According to Canadian immigration law, specifically paragraph 117, subsection 9D of the Immigration and Refugee Protection Regulations, if you don't declare a dependent when you apply for PR, you can never sponsor them later. And before you say, but Mr. J didn't even know he had a son, the law does not care. Whether you know it or not, the rule will still apply. So, ouch. Mr. J tried to fight the decision. He felt that it was unfair because he had no idea his son existed. But the Immigration Appeal Board shut him down. And here's what they said. First of all, a rule is a rule. If you didn't declare dependent before you have landed in Canada, they cannot be sponsored later, period. Secondly, the law applies to everyone, whether you knew about the child or not. And thirdly, if he wanted to get special consideration, there was an option. He should have applied based on humanitarian and compassionate grounds instead. And just like that, his case was dismissed. So what can you learn from Mr. J's case? Here are 3 major lessons. When applying for permanent residence, list every single family member, even if you're not sure about them. If you ever find yourself in a similar situation, apply under humanitarian and compassionate grounds. This is your best chance to argue for an exception. Finally, get professional help because a small mistake in your immigration application can cost you big time in the future.